Wonderful. Well, good morning, everyone, and welcome to Ask an Attorney. This is a hot seat session with Joshua Irvine. Oops, sorry, I'm getting some feedback here. We're so glad that you're here. Today's workshop is designed to give business owners and professionals like you the chance to ask your real-world legal questions about business structure, contracts, construction law, lien law, estate planning, probate, and anything else we might be able to slip in there under Joshua's nose and see if he'll actually answer it for us. Here's how the hot seat works. Here's how today will flow. We will spend the next 30 minutes with Joshua in the hot seat. He's going to be answering as many questions as possible. If you have sent me questions ahead of time, they're already in the queue, and I will be posing those to Joshua in order. You're welcome to type additional questions into the chat at any time. And if we don't get to your question today, please know that I will do my best to circle back with you afterwards and make sure that you receive your answer, because I want this to be valuable for every single one of you who's carved out some time to be with us today. So thank you. Out of respect for everyone here, I ask that you please keep your microphones on mute unless you're invited to unmute, or if I've asked you to please ask a question directly. That may help us minimize that background noise and keep the conversation clear so everyone can hear. This is meant to be an interactive session. So if you do have questions, like I said, put it into the chat, ask what's on your mind. And without further ado, let's go ahead and get started. Joshua, are you ready to be put in the hot seat?
Yeah, I'm excited for it too.
Okay. I'll either have a job after this or I won't, right?
Yeah, there's no
questions are. Yeah. Okay, so here's our first question, Joshua. We are a general contractor. Is it possible and acceptable to have a subcontractor agreement that is only signed once a year if we only use the sub, or if we use the sub all the time? So we could have 20 jobs going and we're using those same subs across all of our jobs. Or do we need to have one signed on every job? So let me refresh that. Is it possible and acceptable to have a subcontractor agreement that's only signed once a year? Or do we have to chase them down for a subcontractor agreement on every job?
Okay. Yeah, and I'll even answer it a little bit more broadly to apply to any time we have like 1099 contractors who work for our companies, to make this a little bit more relevant to anybody. But the short answer to both of those questions would be yes. You can have what's called a master subcontractor agreement, whether that's with subcontractors in a construction setting or subcontractors in a technology setting or a service setting. But ultimately, that main contract is still going to be your binding contract. And you typically in those settings would have something like what we'd call an SOW or statement of work or something like that, that would then outline the specifics of each job. So it wouldn't change the majority of the terms, but it would change the specific scope for a job or a project. And maybe the compensation might be different. And obviously the location, if there are in-person requirements for a job, so that's kind of what a statement of work would be. So you would still need to issue that for each subsequent project or job or task, depending on how you use it. But you can have 99% of the boilerplate terms and condition lawyer junk already ironed out in advance.
Okay, great. Thank you very much. The person asking that question will be significantly relieved to know that they can implement a master subcontractor agreement. Okay, next question. If two parties work off of a handshake deal, what are the legal consequences if things go wrong? And I know that's a big question, but what would be your immediate answers to that? So if two parties work off of a handshake, what are the legal consequences if things go wrong?
The biggest problem is actually interpreting what a handshake means, as silly as that sounds. And I'll give you an example we've all done plenty of times. When you have contracts, what we're talking about is a written agreement between two or more parties. And most of us are entering into contracts, frankly, by text message. Now, we might be in an industry that doesn't allow us to do that. For example, you can't sell a piece of real estate with a text message. But for a lot of other industries that don't have those kind of rules, you can definitely have contracts through text message. And so in a hypothetical, handshake agreement, I had a situation that ended up being a lawsuit for several $100,000 that was a dispute about what a thumbs up in a text message meant. Like, did that mean I agree? Did that mean I wish you would charge me more? Did that mean I just simply want to indicate that I have read your message and not ghosted you, but meant nothing else? And legally,
Wow.
I'm glad I wasn't the judge in that case. But that's really where it comes down to a problem of just really interpreting what did party A mean and what did party B mean. So you're trying to figure out what's the agreement. And if it's a handshake, it's really hard to figure that out. And then from a more practical side of it, if you just have a handshake, a lot of times you're not going to get things like interest. You're not going to get things like attorney's fees, because nobody's going to say that that's what the handshake was. So
Gotcha.
it's a hard situation.
Well, I like learning that you've had a situation like that that involved an emoji. That's a new one for me. Okay, next question. I have been operating in my business as a sole proprietor for years. What is the biggest risk for me of not forming a business entity?
Yeah, that's actually a common question. A lot of people will go online and they'll set up a DBA, so they'll have like a business public name, and they'll unfortunately misunderstand what that actually gives them. So the two biggest things that you miss out on if you're only a sole proprietor, number one, you miss out on the protections that separate your business from your personal life. And that is unfortunately becoming more and more real for too many industries. And number two, you're actually losing out on some tax strategies. When you're a sole proprietor, you kind of get hosed on a lot of things from a tax perspective. And so although it's true, you're going to have to spend a little bit of money going through setting up the company and maybe having the right kind of tax team with you. In my experience, you usually save a lot more money in the long run by going through that process than just maintaining status quo.
Great, thank you.
Yeah.
And thank you, Rita. I saw your question pop up. I've put it into the queue. What is one legal myth that you hear all the time from business owners that just isn't true?
Okay, that's a good question. Well, I guess, and this is probably a little bit of a touchy subject for businesses and employees alike. Maybe this is a good time for me to say, I represent businesses, not employees. So a lot of the myths that come up sometimes are the tension between that dynamic, between who am I representing. But one of the most common things that comes up, and this is going to be different in every state, but most of the audience today is Utah based, and so we're focusing on Utah stuff. Although I'm licensed in multiple states, I'm just talking about Utah stuff. So I just don't want a bunch of comments later saying that's not true, because every state is different. The biggest myth I see in Utah is that non-competes are unenforceable. I'm not saying whether it makes good sense for a company to enforce a non-compete, but when a company protects their business and their interests and what they've built, I hear a lot of times companies say, hey, I can't even enforce these agreements. Why would I ever have them in the first place? And that's a myth. Utah allows you to enforce them. Now, I say that doesn't mean it makes sense to do. Like, there's policy and there's culture and there's perception and all that fun stuff, but they are 100% enforceable if they're done the right way.
Very good. I've actually had that myth come at me a couple times, and so thank you for sharing that. All right, next question. This is also coming from one of our subcontractors. I have a homeowner that owes me money on our last invoice. It's around $42,000. Why can't I just take them to small claims court?
Oh, wow. That's a big bill. So I guess the first question in there is, why aren't we billing more regularly to allow a bill to get that big?
Mhm.
But let's just assume that they were on top of things and they just had a lot of work at the end. This is probably applicable for any business that's owed money of any amount. So there are, at least in Utah, and again, every state's a little bit different. In Utah, there are technically 3 courts where you can file lawsuits in order to try to get money back. It could be a contract claim or a collections claim, but there's 3 basic courts: small claims court, and then you have what's called district court. And a couple of years ago, Utah legislature created a new court called the Court of Chancery, or the Chancery Court, which is just a specialized court for business construction or business contract disputes. So you can always take a claim to small claims court if there's a dispute about money. The issue with small claims is you can only go there if it's a dispute about money. You cannot go there to get divorced. You cannot go there to foreclose on liens. You cannot go there, for a lot of those other issues. You can only go there if your ultimate claim is about money. So number one. And number two, you can only go to small claims if you're willing to cap the amount you're willing to claim. And this is true in any state. The amounts are different, but the principle's the same. If you go to a small claims court or a justice court or whatever they call it in your state, it's going to be capped. In Utah, we are capped at $20,000. That changed this year in January, and in a few years it'll change again. But so if you have a $42,000 claim, you can definitely go to small claims court, but your claim must be limited to $20,000. Now, why would somebody willingly walk away from $22,000 in this story? Usually it's because it's cheaper and faster to go to small claims court than it is to go through the whole traditional process of district court. It's faster because the rules are different, they're expedited. It's cheaper, frankly, because the rules are relaxed and you are not required to have an attorney do everything for you. There are a number of my business clients that still hire me to do their small claims case. But even then, because it is very, very quick and very relaxed, I can give it to them on a very flat fee pricing so that they know up front. So there's just some analysis on that. Usually some people are willing to walk away from some of the money so that they can get it done faster than potentially spending 1 or 2 years and tons of money to try to fight for the whole amount.
Okay. Great. Let's see. If you could give every business owner one piece of legal advice that would save them time, money, or headaches down the road, what would it be?
Well, I'm a business guy. Like, my approach to a law firm and to my clients is from a very much a business perspective. And I teach, and I'm an adjunct professor, and so I'm not the typical lawyer. So my approach is more business advice than legal advice. But the business advice that I'd give is to create systems in your company. Systems are things that can repeat, that can regularly occur, and that do not necessarily require your direct involvement as the owner of the company. The ability to have systems and then to train great staff to follow those systems is going to free up your time. It's going to allow you to give back to your community, to your faith, to your family in ways that you can't do if you are requiring everything to come through you. I can't do it. That doesn't mean that there aren't times that I get frustrated because I can't do it all. But I have to remind myself that if I want to have a life, if I want to serve my family, my friends, my community, if I want to see, catch a sports game, if I want any of those kind of things, I have to create systems in my company so that my clients don't have an interruption in service, and so that I don't have a mental breakdown trying to do it all myself.
Fair enough. Okay, thank you. Let's see. Why do contractors sometimes lose their lien rights, and what simple steps can prevent this from happening?
Yeah, contractors are unique that they have these construction lien rights. The reason why many of them lose those rights is because they are unaware of the procedures and the deadlines involved in the enforcing and protecting those rights. Which usually kind of comes down to what I just mentioned, where they don't have a good system around how to do those things, how to start the process of filing the necessary notices, how to follow it up, how to make sure they don't miss deadlines in the future to foreclose and protect those rights. It's usually just not knowing how to do things. It's not because they're unintelligent. It's just, oh, I didn't know I was supposed to do it that way. I mean, frankly, a lot of people I know are super smart in their businesses, but these are small things that are easy to forget, easy to not remember, and are perfect for having systems. So whether that's a system that you design internally or whether you hire a company to help your company do those things. Like I literally was talking to a construction company yesterday. They're a $20 million a year company, and yet they don't have a good system around their liens, which sounds silly, but because it's just such a simple thing to overlook. And so they reached out and said, hey, will your team handle this? And of course, we're happy to help. We're also happy to teach them how to do it themselves. We don't need to be everything, but that's our approach. And in my opinion, the reason why contractors miss lien rights, I would say just more generally, the reason why anybody misses the ability to enforce things is usually there's some deadline tracking that needs a system in order to manage it. I had this teacher in high school that I really liked, and he used to say all the time, the palest ink is better than the strongest memory. Mm. And a lot of times people try to remember all these moving deadlines, moving parts, and we forget one, and it's always the one we forgot that's the one that bites us. So it's just how it goes.
Yeah, for sure. Oh, I love that because, not that I'm a note taker or anything, right?
Yeah.
All right, shifting gears a little bit. For business owners, what's the difference between simply having a will versus having a fully developed estate plan when it comes to passing on their business?
Okay. That's a good question. It's one of those things that I think a lot of business owners neglect to really figure out because we're never going to die. We're always going to be healthy, and it's always on the to-do list that never gets done. From a high level, and I'll just say from an individual side, I'll just kind of compare two parts. There's the individual side and then there's the business side. On the individual side, we are all a lot more familiar with what that looks like because we've seen mom or grandma or a cousin or an uncle or a father go through some of these issues. And if on the individual side you pass away and you have a will, legally a will does not become functional until it's triggered, and it's not triggered until someone dies. And so because of that natural course, a court is required to verify that this was the true final last will, which requires you go to court, and it's a process called probate. Assuming nobody fights about it, it's not super complicated, but it does cause a delay. It's a stressful period when families don't want to have to be going to court. Obviously, it's the least important thing at that time in someone's life, and yet it can become important if they need access to accounts and finances, etc. So a will by itself is a problem on the individual side, which is why I always recommend families or individuals put together a trust while they are alive, a revocable trust, so that it is funded and effective while they are alive, so nobody's going to court later, and that they can still change and make amendments throughout their life. That's why it's called revocable. On the business side, a will doesn't work at all. Like, you can't just will your business. Your business has to be structured in a certain way to where the ownership and the control is transferred the right way. A business is considered a piece of property. And if it's going to be transferred, it has to be done the right way, or else, families and those who have claims on that business will end up in court. And I've seen this happen a lot. The owner of a company has an accident, whether it's on the job or not, doesn't matter. They pass away. They didn't have all the documents in order. The company can't make payroll. Nobody can access the bank. Nobody can execute leases. Nobody can sell the business assets until you go through a court process and deal with those potential issues. So although they sometimes overlap between business and personal, they are definitely separate procedures. My approach is kind of a 4-step process where number one, we make sure the family's organized the right way. And then number two, we look at the business. And then number three, we look at the asset protection overall strategy. And then finally, we look at tax planning if it's necessary. And we kind of just fall off that 4-step process when it makes sense for us and for our financial reality. I hope everybody has to go through tax planning at some point, but what that means is that you have an estate that's about 10 million or plus. So I hope everybody gets to that stressful time in life to have to worry about planning for it. Maybe for most of us, we'll never get there, but that's the plan. Most people just deal with personal, like family stuff, business stuff, and a little bit of asset protection. That's the majority for business owners.
Wonderful. Thank you. How often should a business owner revisit their estate plan, especially if their company is growing or they've brought in new partners?
Yeah, good. It's a good question. I guess my silly answer, but also serious answer, is you should review it every year at your corporate retreat at your sunny beachside company meeting. So, and so I'm giving you the tax advice and the timing at the same time. But seriously, if you want to write off those things, you need to make a business purpose for those kind of events. And reviewing business succession plans and growth is definitely one of the things you could do. But if that's not your speed, if that's not your jam, I would say at least every 2 to 3 years, you should be reviewing it, just to make sure, whether on the personal side or the business side, just to make sure it still reflects your intentions, your wishes. Life changes, priorities change. If you pass away and that document is super outdated, it's not very helpful to the people who are left to pick it up.
Yeah, thank you very much. Next question, Joshua. How do I protect my brand name, logo, and content from being copied by others?
One of the first things you could do is obviously a trademark application. If you feel like you're going to be doing anything outside of your local area, is a trademark. You could also use copyright protections in the same way for anything that's written or music or those kinds of things. The flip side of it, though, is you also have to be willing to defend it, which can be expensive. So it's not enough to just get those protections in place. You have to actually fight people, sue people, send out nasty letters to protect what you've built. Because if you don't, then the way at least it would work on the trademark side of things, if you don't defend your claim, you essentially are surrendering your claim to it being only for you. Mm-hmm. And the other side of it is just a little bit of probably misunderstanding. Even if you get a trademark, your only protection on a trademark is where you are reasonably using that in business. So if I get a trademark here, okay, my last name's Irvine, and so everybody thinks I'm based in California because of Irvine, California. And so when I was trying to get my domain name for my law firm, they were like, here's $20,000. I was like, nope. Because they assumed I was some big law firm in Irvine, California. So even if I get my name, I would not be able to prevent anybody else in the world from using something that's similar. I could only prevent people in my reasonable business market. So if my business market's in Utah, that's what I'm protecting. If my business market is Utah and Arizona and Colorado, fine. But I'm probably not going to be able to find somebody in Florida and say, you can't use my name, even though I'm not doing any business there. That's the only disconnect.
Okay. What are the most common tax mistakes that small business owners make from a legal perspective?
The biggest one is probably choosing your team. And what I mean by that is there's two basic types of people that work on taxes. There are what I call tax filers, and then there are tax planners. So tax filers are super good at their job. They know where all the forms are. They know the deadlines. They know where to calculate stuff, and they know how much money to tell you to pay. That's their job, though. They're a tax filer, and a lot of people are competing on tax filer prices. The biggest thing that I see for companies that are at least making, $50,000 or more in profit per year, they're losing money because they have not yet probably found a tax planner, which is someone to figure out, how do I use certain strategies to reduce my tax burden. We're not talking about doing illegal stuff here. We're just saying utilizing the available laws for them as a business owner. So how do I put money away into retirement as a business the right way? How do I pay my kids if I want to? How do I rent my home if I want to? How do I depreciate and claim certain benefits under the, I don't remember what it's called. We'll just call it the new Trump law, the new Trump tax law. How's that going to affect me? If you get on TikTok, you're going to find a whole bunch of misinformation, but because it sounds cool. But those things don't apply for every business. So that's probably the biggest thing, is knowing, hey, I'm going to have to spend a couple $1,000s if I want to work with a tax planner, and yeah, that's probably a lot more than it costs to hire a tax filer. But the, I don't know, $1,000 or $1,500 that you're paying extra, if you can't save that much by using a planner, then that's not a good planner. I just got off the phone with somebody who was working with a tax filer 2 weeks ago and was told that they had a tax penalty of over 6 figures. And I'm not saying that they did a bad job. They did a great filing job, but they didn't do a good planning job. And so I said, great, let's talk about risks of these strategies and these strategies so you can make informed choices. And ultimately, we cut their tax burden by about 70%. So I say that for 2 reasons. 1, tax planning works. 2, don't confuse tax planning with I don't still owe taxes to some degree. They still have to pay taxes. It's just in a more strategic way.
Got it. Thank you.
Yeah.
How can I protect my personal assets if my business is ever sued?
The first thing is to make sure your business is properly insulated, meaning that you're in an LLC or a corporation of some kind. The second thing, which is a little bit overlooked, is to make sure when you sign contracts, you sign as the company. A lot of us use our name and we sign our name, but when you're signing on behalf of a company, you have to use your name and your title. So my name / manager, my name / owner, my name / president, and you have to have the name of the company listed in that signature line. And so then you're not becoming personally responsible by accident. You're still signing as the company. So that's number 1. Number 2 is the signing. And then number 3 is do not mix the finances between your business and your personal life. Those are the top 3 ways that you can mess up the distinction and expose your personal life to liabilities.
Okay, good deal. What would you say is the best business structure for long-term growth and liability protection, whether it be an LLC, an S Corp, or a C Corp?
An LLC is the easiest way. It's the most flexible. An S Corp is a tax determination. So you can file as a corporation and then you tell the IRS you want to be taxed like an S Corp, or you can file as an LLC and you tell the IRS I want to be taxed as an S Corporation. I personally think an LLC is the easiest one and it's the most flexible with the ongoing compliance and kind of corporate structure stuff. But if you're making at least $50,000 a year in profit, you should be taxed as an S Corp no matter which way you originally set it up.
Can you say that amount again? What amount?
$50,000 a year in profit,
Okay.
you should be taxed as an S Corp.
Okay.
The difference is if you don't, you're wasting tens of thousands of dollars every year in self-employment tax.
Okay. Are there specific contracts or agreements that every small business owner should have in place to prevent legal issues?
Number one, I'll call it a service agreement. So that'll be different in every industry. Whatever your agreement is with your customer, a service agreement is what I'm going to call it. Number two, it may not be a contract, whether it's a contract or not, an employment agreement or an employment policy handbook. Those are probably the two biggest ones. And then if you have subcontractors, that would an independent contractor agreement of some kind. Those are probably the three biggest ones that cause problems for companies, is not having clear terms with clients, not having clear terms with your subcontractors, and not having clear stuff with your employees.
Very good. Well, we are at the end of our hot seat session. You can take a breath now, Joshua. You've been giving us all your thoughts and insights over this last half hour. Thank you so much. Is there any pieces of wisdom or thoughts from current situations that we've been handling at the firm that this is a message you want to get out today to everybody who's on this call or watching this recorded video?
Well, first of all, I just encourage you guys. I love the entrepreneurial journey, and you guys are in the trenches. So for sure, good job there. Keep it up. It's hard work. With that, I would just say to make sure that you keep focused. And if you've never taken the time to do this, to take some time to focus on why it is you even do it. And if your answer is to make money, I'm going to push back and say that that's too shallow a purpose. So being motivated by some other reason, whether it's family, whether it's faith, whether it's community, whether you're giving back, you're building something, you're helping others, whatever it is that you have, remind yourself and make sure your team knows what that vision is too, because when you get the sucky days, and we will all have them, that's really what helps us get through some of these struggles. So that's what I'd say.
That's great. We've got one last question that I'm going to squeak in there because you know that I like to do that. I like to squeak things into your calendar. I like to squeak things into meetings. One more. What's the best way to refer you and the firm to our business owner friends who could use your services?
I think the easiest way is, number one, don't tell them I'm an attorney, because they'll be like, I hate attorneys, and so do I usually. But I think it's just a matter of people that are expressing frustration and stress in managing and running their business would be a great person for us to talk to, because one of my real mantras is helping our clients take the stress out of running their business. We're not taking it all. I would die. But we're helping take that stress out, and you're getting an extra pair of hands and a team that's going to help you carry that burden. So if you hear about stressful business owners, that's somebody to have called Mel or myself, and we'll see what we can do to help.
Awesome. Well, thank you, Joshua, very, very much. Thank you for allowing me to put you in the hot seat. You did survive. Thank you to folks that were able to join us today, and to those of you that are watching the recorded version because you weren't able to get on or your schedule changed. Not a problem. We appreciate you being here. If you do have any legal questions or need some legal support, you know how to find me. You can reach out to our office, or most of you on this call have my cell phone number. But in case you don't, that's 801-529-2905. And my email address is super easy, melissa@irvine-legal.com. Thank you, everybody, for being here today. And thank you again, Joshua. We'll see you in the next hot seat.
Thanks.
Okay, see you. Bye-bye.